Commissioner Clayton, we still have you? Commissioner Clayton?
Yeah, I'm here. I'm
Okay.
sorry, I had it on mute, so yes, I'm here.
No problem, just want to make sure. All right, we'll call Wednesday, April 10th, the agenda for Wednesday, April 27th to order. It is about 9:35. We've got seemingly a long agenda, and we're going to take some things out of order in order to accommodate schedules for everybody. So we're going to go to the minutes, and then we will take the Empire order because they're on the phone, and we'll allow for questions, and then we will go to all of Judge Woodruff's orders so he can be downstairs so the Ameren hearing can continue. Normally we do this at noon, but because we have so much stuff and we have some discussion, I wanted to get this out of the way. So the first item are the minutes of Tuesday, April 19th. Has everyone had a chance to review, and if so, are there any corrections or changes?
None here.
Anything? Nope. Commissioner Davis, any changes on the minutes?
No.
All right, all those in favor of approving the minutes for Tuesday, April 19th, signify by saying aye.
Aye.
Opposed? All right, minutes are approved. All right, now we will call up, we'll go to tariff and new orders, number 2, EO-2011-0066, Empire District Electric Company, order approving non-unanimous stipulation and agreement and accepting integrated resource plan. Judge Steerley. Judge, you want to just tee this up?
Yes, Mr. Chairman, I had brought this order to agenda a couple of weeks ago, and I believe a couple of the commissioners had questions for the signatories to the non-unanimous stipulation agreement. And even there has been no opposition to the agreement, even from the parties who were not signatories.
So just to recap, it's a non-unanimous stipulation agreement, although we have no one has filed for opposition, so we can treat it as a unanimous step. All right. If Empire on the phone, if you just want to quickly identify yourself who the person is that's available to answer questions, that would be great.
Okay. My name is Todd Tarter. I was the project manager on the Integrated Resource Plan. We also have Barry Warren, Aaron Dole, Scott Keith, and Sherry McCormick in the room.
Excellent. Thank you very much. All right, Commissioner Clayton, any questions for Empire?
No questions, thank you.
All right, Commissioner Davis.
I guess, Todd, I will start with you. In terms of, and if you're not the right person, and I guess what are the important takeaways from this IRP filing from Empire's perspective, if anything? I mean, what are the key points that this commission needs to know and be aware of?
Well, as far as the plan goes, I think that probably from Empire's perspective, it's a 20-year plan, but there were some things that were in the more near term that it was important for us to study, and we thought of as special study factors. For example, some of the potential the environmental laws that could affect around the 2015 time frames, and what kind of impact that would have on some of our older coal generation. I would say that was, for us, the most important things that we were studying.
And the fact that you may have to add scrubbers on some of those units or close them.
Exactly. So we did a lot of scenarios around those type of issues.
And if this is HC, just stop me. But where does Asbury fit into that?
Asbury was one of the units that we did a lot of different scenarios around, both on, like you mentioned, retrofitting or potentially retiring. So I'll just talk about it in general terms. We actually did a study. We had Black & Veatch do a study for us to look at the potential technologies for an AQS system for that unit, and we used a lot of that information in the IRP this time.
Okay. Obviously, Empire has a rate case pending with IATN 2 expenditures in it. You are also a partner in Plum Point. Is Empire good on baseload generation, or are you still looking to add some baseload?
I think at this point, we did look at, I think in the near term, we're not looking to add base load. We did look at some scenarios around in the future, post 2010 or so, would there even be coal available in the future? But we've got some scenarios that does allow coal generation. We did look at, obviously, the IRP has us look at a lot of different technologies. We did look at the potential for us to be a potential partner in nuclear, but it would be, I think that was in the later years of the IRP.
You're talking 2020 to 2025?
Yes.
Okay. I don't think I have any other questions, Mr. Chairman.
Great. Commissioner Jarrett.
I don't have any questions, and I support the order.
Commissioner Kennedy.
Yeah, I had one question, and I don't know if it's appropriate for staff or for the Empire representatives on the phone. If I get into anything that's HC, please stop me. Staff expressed a concern in its report with the load forecasting methodology and expressed concern about lack of data and the presumed growth rates being too high, and then recommended that there be a consultant, I think, hired. Is that an accurate summary of staff's concerns and recommendations?
Yes, it is.
So my question then is, are we confident that those issues will be resolved by the 2013 filing? And how will the selection and hiring of the potential consultant be conducted? Will that be in conjunction with staff, or will that be entirely Empire?
Let's let Todd answer.
Okay.
Yeah, I think that would be entirely with Empire. We actually had waivers for this IRP in the load forecasting area. So we did it explicitly like we said in our waiver process. However, I think what we kind of got caught a little bit, I think what we were trying to do was match up our internal budget process with the way we load forecast for the IRP, instead of doing what the IRP recommended with the in-use stuff. I think with all the economic upheaval and everything, we got kind of caught in that our load group, we kind of did a return to normal by the end of a 5-year forecast. We'd probably do that different today. I think when the stakeholders did their reports, they had the benefit of looking at 17 months later, because the load forecast is one of the first things that you do, and seeing that our growth was too high, and I think that's where the concerns were. And in fact, we've done an new internal budget since then, and we've lowered our forecast accordingly too. But as far as the waiver process, we did agree to do a feasibility study to look at changing our load forecasting for the 2013 filing, and we've already contacted a consultant to give us some ideas for that. We've given them the new IRP rule, the revised rule that's going to be coming out. We showed them the concerns that the stakeholders had this time, and we do feel like through the advisory group process, if this stipulation and agreement lines out, we will provide them that feasibility study and to the advisory group and work together with them. And if there's any consultants hired, that'll probably be one of the options, is hire a consultant to just do it, or have a consultant kind of teach us what we need to do it in-house at Empire. But I think as far as a consultant, it will be, Empire will be the one that will hire that and work with them.
And staff's comfortable with that, and comfortable that that'll be satisfactory for the 2013 filing?
Yes.
All right. That was the only question that I had. Thank you very much.
You're welcome.
Mr. Chairman,
Yes.
before you conclude this, I did want to ask one question when it's appropriate.
Please, go ahead.
Just coming back from the Southwest Power Pool meeting down in Tulsa, over the last couple of days, the big news was Entergy proposing to join the Midwest ISO as opposed to joining SPP. There are obviously a number of questions about whether they're sincere and how long it will take, if it will ever happen. I wanted to ask, what that decision would have, what impact does that have on Empire's planning processes in the future? What does Empire think of Entergy's proposal, and will it affect them in any way?
Mr. Commissioner, this is Barry Warren with Empire. We're disappointed in Entergy's announcement to continue to work with MISO other than SPP. Of course, since we've got Plum Point in the Entergy system, that just presents an issue for us to continue to work with Entergy and MISO on. We do have transmission service from Plum Point into the SPP, and so we'll just have to work through those issues related to seams. And so, like many folks, we're disappointed in their decision. We're not quite sure how sincere they are in actually moving into MISO, but we will be monitoring those activities fairly closely.
Barry, do you think this issue is a high-level concern that would require Empire's participation at FERC if and when they ever do file?
Well, we've currently intervened in a current dispute between SPP and MISO regarding the use of or operation of the joint operating agreement between the two RTOs, and so we're going to participate in that process, and then we do anticipate participating at the FERC level and any of our state commissions activities related to Entergy's move. And so because of Plum Point and because we are on the seam there between SPP and MISO, it will affect our system.
Do you believe there is a role for the Missouri PSC in either FERC proceedings or otherwise with regard to these issues?
Well, as you monitor the process, we would encourage, all.
Barry, you laid it out there.
Agreement is a big deal, but at the same time, the Missouri Commission specifically has Ameren that is participating in MISO, so that may be a little bit of a trickier situation there. But with respect to their request to the FERC to participate in MISO, if the issues are not resolved satisfactorily to Empire and the SPP members, I think the Missouri Commission ought to definitely consider possible actions at FERC whenever that docket gets going.
Thank you. No other questions.
Go ahead. Barry, this is Commissioner Davis again. In terms of the MISO interpretation of the joint operating agreement, does MISO's proposed interpretation, how does that affect Empire?
Well, clearly we're in disagreement as well as Southwest Power Pool in their interpretation of certain sections of the joint operating agreement in terms of the use of the interconnection between the two RTOs, and simply what they're contemplating is a material change in the joint operating agreement and the relationship between the two RTOs, and so that requires further negotiation and work. The bottom line is an integration of Entergy into MISO will affect the SPP members, specifically Kansas City Power and Light and Empire and those on the east side of the system and Nebraska entities. And so, we believe that additional things need to occur in order to make it acceptable. And they possibly need to build additional transmission infrastructure in order to adequately integrate Entergy into their system. And so We've got lots of issues that really need to be addressed for that type of material change between the two RTOs.
And Barry, are you aware that your 2013 IRP filing is going to have a transmission component in it?
Yes.
Okay, and you guys are preparing to meet that obligation in your 2013 filing?
We will be. One of the person that was working on that, it was coming to the workshops when the revised rules was working with Sam McGar, and he's actually taken another job within the company. So we're going to be gearing up for that.
Hello? Okay, are you guys? Yes.
He may be here.
Yeah.
You mean Commissioner Clayton? I think he may be here. So.
Yeah,
Um,
Mr. Clayton just walked in the door.
Okay.
Barry, let me ask you this one question. What share of the SPP operating expenses does Entergy pay? Do you know?
Entergy does not pay any, let's say, material share. They pay the $6,000 a year membership fee.
Okay, so they don't pay anything else other than that $6,000?
Of course, they pay through their service agreement. The independent transmission coordinator, if you will, the ICT.
Right.
They pay, I think, the SPP approximately 3 to 4 cents a megawatt hour per year for those services.
So when those revenues go, if those revenues go away to SPP, is that just a wash because they're no longer providing those services, or is that going to leave a hole that has to be backfilled?
Definitely, if the ICT arrangement, the 3 to 4 cent per megawatt hour arrangement goes away, the ICT services goes away, and they integrate into MISO. That basically places the additional 3 to 4 cent per megawatt hour a year burden on the SPP members.
Do you have any idea what that burden would be on Empire or on KCP&L?
No, Commissioner, I haven't calculated that. Our percentage of the O&M expenses for the most part are about 2.7% of all cost. So, I could do it, real quick, but it does have an effect on us. And, with Entergy migrating or integrating over to MISO, there could be also another effect of the reserve sharing program. They are a significant participant in SPP's reserve sharing, and so we have to assess what the impact of that will be as well if they integrate over and when.
So you basically got the issue of the reserve sharing, which if that goes away, it's a significant amount of reserves because Entergy, across the Entergy system, has excess capacity. And then also you've got those costs. Is there anything else we need to be looking at there?
Again, the fundamental issue that we're all dealing with now in the joint operating agreement is the loop flows and their use of our system to integrate into the MISO market. And so that's probably the number one issue that we'll have to deal with. Reserve sharing may not be as big of an issue when the SPP next day market starts in 2014. We got to all work through those particular changes. But the use of the SPP member system and Kansas City and Empire system has to be dealt with before they should be allowed to integrate.
Okay. Thank you, Mr. Chairman. Thank you, Barry.
Thank you.
No problem. These are going to be issues that we're going to have to monitor carefully, and we are in an interesting situation because we've got folks in both MISO and SPP, so we're going to have to monitor it, keep an eye on what's going on, and we may actually bring you guys back as when we get further along and have presentations from you and from other folks, so we can get a better idea about where we are and if there's anything we need to do. So, are there any other questions for the Empire folks? All right. Well, let's go ahead, and all those in favor of the order approving non-unanimous stipulation and agreement and accepting integrated resource plan, please signify by saying aye.
Aye.
Opposed? All right, that is approved. I don't know. Empire, are you guys gonna hang up, or are you guys gonna stick around and listen to us? And
I think we're going to plan on dropping off and maybe catching it on the web.
that sounds great. I guess we're okay on the drop-off? All right. We have some interesting technological issues, so I just want to know. So thanks very much, and we will, all right, now we are going to, as we go through the agenda, we are going to pick up all of Morris's, Judge Woodruff's orders. So we're going to take this somewhat out of order. Yeah, I think we're good. All right, so we'll call up AW 2011-0330, order directing staff to investigate and opening of a repository file. This, I want to make something clear, that this is the rulemaking order opening up the docket to take a look at the rate case. And I think we should make it clear that the answer may very well end up being we keep everything exactly the way it is. I don't think there's a predetermined outcome here. I don't think we're looking to change here. I think we're looking at all the possibilities. So I just want to make that clear. But we'll go around and see. I know there's notation by Commissioner Davis, but
I'm fine with the document.
Commissioner Davis?
Mr. Jarrett, do you have anything you wanted to say?
Yeah, go ahead.
You sure?
We got a lot to do, so that's acceptable.
I mean, we're directing staff to invest.
Yeah. I'm sorry. I do have something to say.
All right, I'll yield to Commissioner Jarrett.
Thank you. It took me a little while. I'm a little slow this morning. I apologize for the prompting. Yeah, we're directing staff to investigate this, and basically, I would want to make sure that staff does a 50-state study to see what all 50 states are doing on this issue, rather than just look into things around locally and get feedback from stakeholders here. I would like to see what other states are doing and have staff do that. Otherwise, I'm fine with the order.
I think that is an exceptionally fair point and not a difficult thing to ask. So,
To add a sentence into the order, or consider that as instructions to staff?
Commissioner Jarrett, would you like to add it to the order? Or you think
Yeah, I
that-
would. I think so. Just to be clear to staff,
I'm fine with that. Anybody have any?
make sure they got it.
Well, yeah, since we're tinkering with the language, I think a 50-state survey is probably a good idea of what states are currently doing and what states have examined or proposed or looked at in addition to what they're not actually doing now, but if there's such evidence out there, of just what the other states have considered.
Yeah, sounds fine to me too.
Any issues with that? You're going to write a concurrence, or with that language?
Yeah, I'm still going to write a concurrence because we have a prudent standard, and if it's a prudently incurred cost, it should be allowed. If it's imprudent, it should be disallowed. And I think that's what the standard should be, and I don't think we should, seek to in essence, prejudge that somehow, shareholders, benefit equally or more from a rate case than consumers. So I would say we should just stick with the prudently incurred cost.
Those are some of the questions we're going to seek to answer. So, all right.
I'll have a concurrence to follow.
Okay. So you say yours is to attach? Or it says attach on here. It says to attach, so I just want to make
I'm sorry.
sure.
That was That must be an oversight on my part.
All right, so we'll have
Concurrence to
concurrences to follow
Falling a little behind.
from Davis. All right, so this will be as amended. All those in favor of the order directing staff to investigate and opening a repository file as amended, please signify by saying aye.
Aye.
Opposed? All right, order is approved. Now, we will go to GS 2011-0264. This is the gas safety report, accepting the staff report and opening a repository file. This was an initiative that was started under Chairman Clayton, and so I'll turn it over to him to talk about where we are and give a little update.
Thank you, Mr. Chairman. This process started last year when we began with some inspections of our natural gas distribution systems around the state. Since that time, we've had an opportunity to go out and provide kind of an impromptu selection of locations around the state, asking the utilities to conduct leak surveys, to conduct integrity testing, that sort of thing. It began with the Ameren system in Center, Missouri, and I think it concluded in Sedalia with, is it MGE or Sedalia? I can't remember where it concluded, but each of the large LDCs were contacted and a survey was conducted. That has become part of the overall study that staff has compiled. And I think what you have in this document, you have in part a backward-looking document that outlines what occurred in the 1990s with the changes in the main replacement programs, with the changes in rules and regulations that are in place at the Commission. Since none of us were here in the early 90s, we were not around when houses were blowing up, when there were significant explosions that were occurring around the state. It is sometimes worthwhile to have that update and reminder of what prior commissions have done and the good work that they have brought forward to this date. However, the document was always also forward-looking and providing an additional analysis of the integrity of the systems. And I think what we found was that those revisions or those changes from the early 1990s are giving us benefits today. We have a lot of outdated pipe that is being replaced, being circulated out of the system, and that makes for a safer system, less prone to any type of explosion. Of course, it's very difficult to keep from any explosion or any accident ever occurring. And so the forward-looking piece of this document talks about some steps that maybe the Commission ought to consider. There are some updates that we can cause in our regulations that would make them a little stronger in relation to the federal counterparts. We have several main replacement programs that are still in the works right now. We could possibly look at accelerating some of those programs if we see fit. Some of them are completed. As an example, I think Laclede's copper service line replacement program has been completed. On the other side, there's an unprotected steel main program which still has 4 or 5 years to go with maybe 10,000 feet per year. But that's something we ought to consider. And the report also highlights the fact that the number one cause, or the majority cause of ignitions of natural gas problems in the state are occurring because of third-party damage, excavator damage, problems with the call before you dig program, and that the docket that we had open from about 2 years ago that would set out new enforcement mechanisms for third-party excavation damage is worthwhile. We ought to continue working on that docket to find some solution, and especially going after the bad actors that continually hit pipe and risk causing damage to life or limb to the ratepayers. So having said that, I want to thank the staff. I want to thank Natel and the gas safety team for all of their efforts and their patience in dealing with my calls to push this issue. Natural gas safety, since we started this process, has really come to the forefront with what happened in California. We've since had 2 explosions or ruptures in the state of Missouri. Each of those are under investigation right now. And I think the public expects us to be doing everything we possibly can in a cost-effective manner to ensure that these systems are safe under the circumstances. So I think we have, the Commission has done great work in the past, but I think there's more work to go in the future. This report sets that out, and as we move forward, it's going to be up to the Chairman on which items that we take up, which items that we don't. But I appreciate staff's involvement. I think it's a quality piece of work. So
excellent. Thank you. Are there any other comments or questions?
Mr. Chairman, I would just like to thank Commissioner Clayton for his work on this. I think we're sort of in the forefront. I know NARUC has a new gas safety pipeline task force that they're working on this, and we're sort of, I think, ahead of the curve on this. So thank you,
Thank you.
or Commissioner Clayton on this, and I fully support this.
And Commissioner Jarrett's our representative on the gas committee from NARUC, so we're going to look to him to help inform to do this. And I think that as a general kind of snapshot of where we are, the leak surveys that we did all turned out pretty good. But this is an ongoing issue. That's one of the reasons why we have the repository file. You can never stop being vigilant. We know our utilities are constantly vigilant about gas safety. Not only from it's a incredibly big safety issue, but there's a revenue issue with ruptures and losing supply and all those issues. So it's one of the most important things that we do, and I think we're going to continue.
And I think it's a great idea that the public sees us out doing these types of things and can feel comfortable knowing that, while we can't stop everything from happening, at least we're being proactive about it, and we're out in the public and out in the field looking at these things.
Absolutely. So, and I also commend Commissioner Clayton's work on this and appreciate him putting it in the forefront of the commission. So, all right, all those in favor of order accepting staff's report and opening a repository file, please signify by saying aye.
Aye.
Opposed? All right. Great. All right. All right. We will move to item number 4, EO-2010-0255 report order. So I think we have been fortunate in my short tenure that we have done most things by unanimous vote, but obviously that doesn't always pan out. That doesn't always work, and so I think this is one of those orders. This is regarding Ameren's fee adjustment clause and the partial requirements contracts. And I know that there's some differences. We've discussed it at an agenda where everybody came down on, but I wanted to, because there is not unanimity here, I want to give everybody a fair opportunity to revisit if they would like to. So,
Mr. Chairman, you should be working off version 3.
Okay.
It says it at the top.
Okay.
I sent it around.
Got it. Yep, I got it.
Okay.
I got the new one. All right.
I do have one other change that I suggest we make, and it's in order paragraph 1 on the very last page.
Okay.
Right now it says Ameren shall refund the dollars to its ratepayers concurrently with its next FAC true-up adjustment. I'm not sure that's correct, and I would suggest we change it simply by an adjustment to its FAC charge, which is actually the language that's in staff's report.
So after ratepayers, it'll say by an adjustment
To its FAC charge.
its FAC charge. And then it's to correct?
Correct.
To correct, okay. All right. Commissioner Clayton?
No, nothing.
Nothing?
Question.
All right. Commissioner Davis?
Well, I guess I would just say that in my 7 years on the commission, this is probably one of those decisions that I would say, this is probably the one that I'm most disappointed with since I've been here. I mean, in the Kansas City Power and Light and the GMO cases, we had a long talk about the prudence standard, and I think what Ameren attempted to do here was what any reasonable person would have done under the same or similar circumstances. They looked at their tariffs and they went out and they signed contracts to replace Miranda's load in the way that they could most closely mirror it. I think that this is just, I mean, we're taking $17 million away from them, and I just, think it's unconscionable.
All right. Commissioner Garrett?
Well, I am a strong no on this order as well. I agree. I think Ameren did what any reasonable company would do to replace a devastating loss due to events beyond their control. They did it according to their tariffs, and to me the commission they were punished because of the storm, and now the commission is punishing them for, to me, no good reason. I think the evidence is clear that these were long-term partial requirements contracts, and therefore, under their tariff, they shouldn't have to refund this money. So I'm a no.
Okay, Commissioner Kenny.
I think the report and order is legally sound and supported by the facts. I'm a yes.
I'm a yes as well, although I will concede that I think some of the procedures and definitions in the FAC are ambiguous, and we may see a rulemaking come through, or at least a docket to identify some of these gaps, to standardize some definitions. I think that was one of the major points of contention about what is defined as a long-term contract, in order to work through some of these issues, and so we may see that coming down shortly.
And I guess, let me just respond to that, Mr. Chairman. I mean, the definition of a long-term contract has changed significantly in the last 10 years, in the last 5 years, in the last 2 years. Long-term requirements contracts are not what they used to be. They're just not. I mean, you have all these other ancillary services and everything that are just getting, instead of whoever's providing the electricity or the transmission company doing it, now, the buyer is getting stuck with all those things, and in many cases, they're just not, in some cases anyway, they're not equipped to handle it. And, I don't think that's just common to the electricity market. I think if you look at the market for alumina and some of the other things out there, you're going to see very similar contracts. And I'm just hesitant to try to define these things too much, because they change, and then you end up with a FERC Form 1 definition that, in my opinion, is clearly outdated, that I sincerely doubt that FERC would even follow today.
Well, I mean, that begs the question. You got a FERC Form 1 that says one thing. You've got market participants that have a different understanding, and I think that points out the fact that there's a lack of clarity as to what the definition was. So, I mean, we can do it in the rulemaking, or parties can more accurately define the terms in the bodies of their contracts themselves as well.
And I don't know the answer, and Commissioner Davis, you may absolutely be right, and I think I just want to make sure that we're aligned and we are better informed about what these things are, to give some more certainty to folks, so they know that what's going on. So I don't disagree with you that the definition has changed, and it's fluid, and it's changing rapidly, and that makes this thing even more difficult. So I don't fundamentally disagree with what you're saying.
And I do want to point out that the problem has been solved, because we now have what's called the in-rider or the in-tariff that, basically prescribes what's going to happen now in case we do have another force majeure event with Miranda.
All right, all those in favor? Anything else? I don't want to.
No.
I don't know, premature. No. All those in favor of the report and order in EO 2010-255, please signify by saying aye.
Aye.
No? You sure you want to do that? I'm going to do that again. All those in favor of the report and order in EO 2010-255, 0255, signify by saying aye. Aye.
Aye.
Opposed?
Nay.
Nay.
All right, that is approved 3-2.
Consent to follow.
Okay.
Commissioner Jarrett, also.
I may join Commissioner Davis's.
That'll push me to work on it.
Luckily, I am not keeping a running total of everyone's concurrences and dissents to follow, nor will I hold anybody to it. Well, we get to go from one fund order to the next one, which is the GR, we're going to call up item number 7, GR 2008-0364, which is the Atmos Energy Corporation order denying Atmos the motion to strike testimony. We, again, have had a pretty good discussion about this, but, again, we do not have consensus on this, so I want to give everybody an opportunity to stake some other claims if they so choose. So I will go to Commissioner Clay.
I don't have any questions on the order. I think this is the right way procedurally to address this and then handle the merits of the case. I recognize the arguments that have been made by Atmos that I support. Commissioner Davis.
Well, I mean, we have rules, and it's up to us as to how we enforce them. And I understand the point that this goes to, we can consider this, when it gets to the probative value of the evidence. But I guess my point is that we have to take a stand at some point with our staff and say enough is enough. And I believe that David Summer is well-meaning and is a good man and is trying to do the right thing. But, I mean, by, in essence, doing nothing, I mean, we are just encouraging more bad behavior, and we are encouraging, the financial services sector of the PSC to just go out and be staff gone wild. They're going to come in and just, they're going to wait until their rebuttal testimony. They're going to change their testimony, and they're just going to consistently do this. And, even though we don't necessarily, we may not agree with them and we may find against them, and still, I mean, to me, it just violates the covenant of implied good faith and fair dealing. And I do not think our staff is dealing fairly with these companies by changing their testimony in their rebuttal testimony. And, I think we need to do something about it. I think we need to take a stand, and I think we need to be consistent about it. And, until then, it's just going to be more of the same.
Commissioner Jarrett.
Yeah, I mean, I agree. I'm a no on this. It is staff that broke the rules by filing new issues in rebuttal testimony in conflict with our rules. And furthermore, I completely disagree with with how the order is written. The company did everything right in this case. When the testimony was offered, they objected. Somehow say that just because something's filed in EFIS, they should have gone ahead and filed objections or done other things before it's even offered into evidence, I think is wrong. I think that's the wrong analysis. I don't think that's the right legal or procedural standard. They offered an objection when it was offered into evidence. The judge, I think, rightly took it with the case. And now that the majority is going to deny the motion to strike, I think Atmos should have the opportunity now to once their motion is ruled on, to seek some other form of relief. And so, for those reasons, I'm a no, and I will have a dissent to follow.
Commissioner Kemp.
I don't have anything to add.
Okay. I don't really have anything to add. I do actually. We are undergoing some reviews of our procedures that will address, I think, some general concerns about this, and hopefully that will be accompanied by procedural orders in every case that will clamp down on a lot of this stuff and will at least get it to the commission or bring it up as an issue in front of the commission earlier and in an appropriate manner. So there are some things that will help us act consistently in every case, and I agree with that. and we're doing that, and that's going to come back here, I hope, relatively shortly. And to Commissioner Jarrett's point, I think that if, I'll commit that obviously if Atmos files for subsequent relief to this, that it will be on agenda quickly, and we won't dilly-dally, and make sure that we can make a determination on the merits on that if and when something is filed. So, all right, all those in favor of the order denying Atmos's motion to strike testimony, please signify by saying aye. Aye.
No.
I'm going to do that again.
You need to pay attention here.
Sorry.
I'm going to do that again. All those in favor of the order denying Atmos's motion to strike testimony, please signify by saying aye.
Aye.
Opposed?
Nay.
Nay.
All right. Order is approved. 3 to 2.
Dissent to follow.
For you too?
Yes.
I know Commissioner Jarrett, dissent to follow. Davis, you as well?
Yeah, just assume everything I'm going to say is to follow.
Okay.
Even if I write something, you don't see it attached to the vote slip, it's following.
It's starting to stack up. All right, so now we are going down to item number 10.
You should have version 2 of this one.
Okay, this is just version 1, but I did get version 2, so I have reviewed it, but the folder is. All right. 10 is ER 2011-0028, Union Electric Company order regarding MIC and Miranda's motion for reconsideration. This is version 2. There are a lot of notations on the vote slip, a lot of questions. Commissioner Clayton.
You don't have any notations on there, so I haven't had a chance to initial that. But in reviewing the filings in this case, reviewing the order, I don't think I can support it. I think the license fee issue is significant. I think it's a significant amount of dollars. I think the way to handle this for MEUA is to challenge the credibility of the witness, and I think the credibility of the witness will ultimately have to be decided by us without the supporting information, rather than requiring the payment of however much money it is.
Is that figure HC?
It's in the order. So the dollar amount, the license fee, I think is an unreasonable request to ask. So I would be a no on the order, and I would modify our previous decision on this aspect of the discovery order.
Mr. Davis.
Well, I'm firmly in support of the order. There were 3 issues in Mr. Woodsmall's initial discovery request: electricity costs, alumina costs, and labor costs. And so, I mean, clearly Fane has relied on the CRA electric costs, and that's I'm sorry, getting CRA because they do the cost benefit studies for MISO and CRU. But thank you. He clearly relied on those numbers. And I'm not sure whether he got the alumina and the labor numbers from Noranda as well, but discovery is much broader. And there's nothing that says that Mr. Woodsmall is going to put this information into evidence, but if they're providing this information to an independent expert that has directly relied on those, then Mr. Woodsmall is entitled to discovery of those documents to assure the independence of the expert's thinking, both in terms of his analysis and his conclusions. And more importantly, if he relied on those documents, or even if he didn't rely on those documents and he specifically discarded the information that was in there, those I think are the ones that Mr. Woodsmall is especially entitled to. This came up in the last Ameren rate case, and I want to say it's maybe transcript volume 30, 34, 35, 36. I can't remember the exact volume of the transcript right now, but I went back and
Very interesting recall.
well, I went back and read
34, can I get a page number on that?
because I remembered having this dispute last time, and certainly during Mr. Woodsmall's cross-examination of Mr. Smith, it looked like that Mr. Smith was actually referring to a CRU Excel spreadsheet, and that Mr. Fain also referred to it. And once again, I mean, if they're going to be sitting there on the witness stand referring to CRU data and then testifying to it, then I think Mr. Woodsmall's, if he wants it, I mean, he's got to be able to have a look at those materials. And I mean, I would surely think that there's some case law out there that says, if it's been furnished to an expert witness, by the company, then it's got to be disclosed. I mean, that's the way I view it. So,
Commissioner Jarrett.
Yeah, I agree. Clearly, under the rules of discovery, he's entitled to it. It's clear that the witness relied on it, and I think that in order to impeach the witness or explore the witness, Mr. Woodsmall is entitled to it. If Miranda doesn't want to pay the $16,000, they can withdraw Mr. Fain's testimony or whatever. But if they're going to rely on it, he's entitled to it. And I'm in support of the order.
Yeah, I am too. I think to deny MEUA the information would be to inhibit their ability to properly cross-examine this witness. So I don't think there's any question that they're entitled to it. I think the $16,000 licensing fee gave me pause as well, but I would be very surprised if Miranda, as an ongoing customer of CRU, wasn't able to get them to waive what is, in the grand scheme of things, a relatively insignificant amount of money. I mean, they presumably pay for this data, and then they provide it to their expert in the first place. And it's not. I mean, Crew's not my business, so I can't tell them how to run their business. But it just seems that Miranda should be able to work out something so they either reduce or minimize that fee. But in any event, if information they provided to their expert, the expert is testifying in the case, and they're sponsoring that expert, and MEUA has an absolute right to be able to cross-examine that expert effectively. So.
I too am in favor of the order. I think that it clearly is discoverable stuff. That the $16,000 fee, quite frankly, should have been contemplated in any agreement that Miranda made with CRU, and when they were proposing to use this as an expert, and they were going to use the expert, it should have been contemplated that someone should have brought it up. And it's a third party issue. It doesn't. It seems exorbitant to me. But it's an issue between a third-party vendor and Miranda. The expert relied on it. They're clearly responsible for providing the information. And really, while the consideration is we don't want to have unnecessary expenses, the information is clearly necessary to make credibility judgments of the expert witness and to intelligently cross-examine. So I think I'm in favor of the order.
Just to add, Miranda did not object to providing the CRU electricity data. So I think that is a significant point. And the other point that I had after going back and rereading the transcript in the ER 2010 case was it was unclear to me, based on Mr. Woodsmall's cross-examination of Mr. Fain, who was referring to spreadsheet data that was provided to him by Miranda, if that was the actual CRU data or if it was Miranda putting CRU data in a spreadsheet and giving it to him, which, once again, could be a very different thing. It could be, they could have, I mean, who knows whether they left anything out or not. I mean, I think that right there to me is another compelling reason why Mr. Woodsmall should be entitled to get this data.
All right. Anything else? All those in favor of the order regarding MIEC and Miranda's motion for reconsideration, please signify by saying aye.
Aye.
Opposed?
No.
It's approved 4-1. All right, I think we have cleared your decks, Judge.
Right on time.
Please go down and make sure they're behaving down there.
Are you gonna go ahead with opening statements and?
I was planning to.
We have a ways to go. We've got to get through this, and then we have to go through.
Could we get them to like hold to maybe 11 o'clock? I mean, I don't think I have much else on any of these other things other than just casting votes on KCP&L. I mean,
If everybody thinks we can move through them quickly.
You have my commitment to move expeditiously.
Should have got that commitment before we logged in. Just tell them 11 and we'll go through. Good luck. Well, we're going to work through this. All right. All right. So we're going to go to, we're going to call up number 5, WO 2011-0213, Missouri American Water. Order granting application to transfer assets, approving stipulation and agreement, and granting waiver. See no questions. Are there any questions or comments? All those in favor of the order granting applications to transfer assets, approving stipulation and agreement, and granting waiver, please signify by saying aye.
Aye.
Opposed? All right. 5 to nothing. I am withdrawing 6. We're going to revisit that next week. So we'll note that as withdrawn. All right. Calling up.
Can we do 13 before we do 7 or 8? Just asking, Mr. Chairman.
Yeah, well, that's fine. We can do that.
That ought to be
I think that's right. The order is like I said. Don't be wedded to the order on here. All right, so we will call up item 13, ER 2010-0355, order denying applications for rehearing. There are no questions or comments on the slip. Does anybody have anything? All those in favor of order denying applications for rehearing, please signify by saying aye.
Aye.
Opposed? All right. Approved 5-0. All right. Now we'll go back to number 8, excuse me. Order approving tariffs in compliance with commission report and order. This is the same case, ER 2010-0355. There are no notations on the slip. Any questions or comments? All those in favor of the order approving tariffs in compliance with commission report and order, please signify by saying aye.
Aye.
Opposed? Order is approved. 5-0. I like the 5 zeros a lot better. All right, we'll call up GT 2011-0335, Atmos Energy Corporation, order approving expedited tariff. There are no question marks on the vote slip. Are there any questions or comments? Seeing none. All those in favor of the order approving expedited tariff, please signify by saying aye.
Aye.
Opposed? Order is approved. We did 10 already, so we'll go to WC 2010-0215, Roman Dzerzhinsky, order adopting recommended report and order. This is Missouri American Water. There may be a question here. Commissioner Clayton.
Judge, I just wanted to ask a couple of questions. I haven't had a chance to look at the recommended order I know the conclusion of the order and how you decided the case. What I wanted to talk about were the timelines, the procedure. This was done under the small complaint case procedure. And so could you give me an idea, how long did it take to process this complaint?
Well, to begin with, I want it noted that by the time the small complaint case regulation went into effect, all the timelines had passed.
Okay.
Taking a look at when the complaint was filed, that was on January 19th of 2010.
Yeah. So this took 15 months to resolve?
It was lengthy. There was a lot of negotiation between the parties, and I really do believe they tried to settle this. Also, a lot of discovery by Mr. Dzerzhinsky. Many filings.
Okay, all right. Well, all right. I thought this was the first one filed under the small complaint, but it was not. This predated, and then you concluded it under the rules.
Correct.
Okay, all right. I have no other questions. Thanks.
All right. Commissioner Davis, you have a notation.
I'm fine now.
Any other questions or comments? All right. All those in favor of the order adopting recommended report and order, in WC 2010-0215, please signify by saying aye.
Aye.
Opposed? All right, approved. 5-0. All right, our last report order before we get to GMO, EE 2009-0237, KCP&L, order directing filing and setting hearing. This is what we discussed last week. Is that right? We talked about this last week?
It was-
And this is the revised order that comes back that directs the
We had-
filing.
We actually had a case discussion.
Number 2 under
last
case
week.
discussion,
First
I
order,
think.
right.
Not the second item.
And it does involve the second item on the case discussion list for the EC 2011-025.
And I will bring that up for case discussion. So, any questions or comments?
No, I'm just a little disappointed that we're pushing it out to July 1st, but I think it's reasonable, and then having the quick turnaround August 1st is acceptable. So I think it's I think if any of the parties feel this is inadequate to address some of these issues, then we can revisit it, but I think this is appropriate to move forward in this way.
Commissioner Davis.
I'm going to vote no on this. In terms of the complaint, I just think that staff's actions were unreasonable, and I think this is another Aspen Woods scenario where, I think it would be intriguing to see what would happen if KCP&L sought attorney's fees for this GMO. I think this is a new IRP filing. I think July 1 is going to stretch them to put together a completed product, but I guess they'll do it because they've said they can do it. Right. I'm just going to vote no.
All right, Commissioner Jarrett.
I'm okay with the order. We're going to an evidentiary hearing. I am concerned too about the cost, running up the expenses, but let's give the company an opportunity to defend themselves and put on a case.
Commissioner Kennedy.
So we're not dismissing the complaint file, we're simply just giving them 30 days to analyze the IRP, and then we'll have a hearing on that, on the complaint case?
Well, the context in which this was discussed last week was, I believe the preference that Commissioner Clayton said was not to be looking at necessarily a complaint and pursuing penalties.
Right.
If you did want to get to the bottom whether or not there was a violation of the stipulated agreement.
Which is what we'll do August 1.
That's correct.
And it'll simply, it'll be in response to the allegations in this EC 2011.
And it would occur in the IRP docket as opposed to the complaint docket.
Okay.
The complaint docket will remain open, and if the commissioners at that time will decide they would want to move forward in that fashion, they certainly can. Presently, the way this is set up is it would occur in the IRP docket.
And what we'll probably do from a procedural standpoint is we'll bring up whatever result comes out of the IRP docket, whatever order we do, we'll call up the complaint and figure out how to deal with it.
So, but I just wanted to be clear, GMO's not having to do double duty in both files. They've already filed an answer, but there's not going to be any discovery, there's not going to have to be anything done in the complaint file. It'll be done in the IRP file, and whatever comes out of that will be applicable to the complaint file.
I believe that's correct.
All right.
That's the intent.
Yeah.
All right. Just not to be repetitive from last week, but I think the point I was trying to make is that there's obviously a dispute here, and staff feels that that the filing did not live up to what they thought it was going to be in the stipulation and agreement. And so you've got this dispute. I just think it's most efficient to deal with it in an IRP setting rather than a complaint penalty type of circumstance. I'd rather get to the bottom of this and let's get a result that moves forward on these types of programs or these types of issues rather than worry about a complaint process, which I think will last forever. Of course, if the commission finds that there's a violation or that the company did not live up to its agreement, then I think the complaint needs to be hanging out there. But it's not my preference to proceed that way. And the July 1st date gives them a chance to supplement. It'll be after their cases are concluded, the rate cases, and they can supplement their filing, and maybe the parties will be able to work towards some resolution in the meantime. And then in August, if not, then we'll be in a position to hear the arguments and make a decision. That was my thinking on it.
All right. Any other questions or comments?
Nope.
All those in favor of the order directing filing, providing notice and setting hearing, please signify by saying aye.
Aye.
Opposed?
No.
Any dissent? Commissioner Davis?
No.
Okay.
No mods.
Busy man right there.
All right, we'll note that as approved. All right, now we will move on to case discussion, ER 2010-0356. This is GMO. Judge Appel, we want to thank Judge Appel for filling in for Mr. Reed and handling our audio-visual and all those other things. All right, so we have the memo for discussion. We've gone through some things. We haven't others. So but we have 7 issues and several sub-issues to kind of wrap up and decide. So we'll start with Commissioner Clay.
Thank you, Mr. Chairman. Going through all the briefs, going through all the materials that have been filed in this case, I'm prepared to throw out positions, and I'm not sure how that will play into where the commission ultimately comes down. On the Crossroads issue, this obviously has a long and sordid history, frankly, going back to the Aquila days. And I really think that if this was Aquila that was filing asking that Crossroads be put into rate base, that we really wouldn't be having that conversation. I just have a hard time believing that Aquila would ever be successful with the challenges that they faced with their steps into the unregulated markets. We have a power plant here that is physically located in the state of Mississippi. It's 2 transmission systems away, relying on gas and argued as a baseload unit. I have a very difficult time with the idea that this is the least cost alternative or that this is the best mix to be added to rate base for GMO. Now, having said that, I think it was an asset that they acquired in the merger. To some extent, they've got it. There have been allegations that they can't get rid of it. They dispute that they've tried to get rid of it. But I have a really hard time adding Crossroads to rate base, just in general. And I certainly have a hard time adding it to rate base at the net book value, which is not reflective of its market value. And we can argue about the appropriate amount if the commission decides it's going to move in. I tend to be supportive of the concept, although I don't think it's optimal, and I have a dissent that talks about the phantom turbines, not in a positive manner, but I think having an amount in there for the amount of power is an appropriate way to include some value in rates without adding Crossroads into rate base. I think the commission ultimately has to make a decision whether it feels this asset should be part of the generating fleet of the regulated asset, and I think its history makes it very difficult for me to do that. And how I probably am going to end up being in the minority on this issue, but that's just the way I feel on the Crossroads issue. I guess if the commission decides that it's going to move Crossroads into rate base, I'll chime in at the appropriate time with the value. On the Jeffrey upgrades, reviewing the filings in this, I was a little confused on the actual amount of the disallowance. Considering this is only, that GMO is only 8% of the overall plant, some of the dollar amounts get difficult in working through. But I was not persuaded that the amount should be disallowed. And the reason is, first of all, GMO is a significant minority party in this plant. I have significant concerns with the financial services or the accounting staff suggesting disallowances based on missed opportunities or liquidated damages or discussing legal strategy. I think there were change orders that suggested an appropriate additional cost to the plant, and so I just, on an overall basis, was not persuaded that we should disallow any of the Jeffrey upgrades. Regarding the IATAN allocation, I think staff raises a very important point, but I think it's a very difficult decision for this commission to make. And the reason I think it'd be very difficult to do this reallocation is that it's doing it in a piecemeal fashion. I think if we're really going to have a conversation about reallocating costs or redistributing any type of cost or expense, I think we really need to have a conversation about whether it's appropriate for GMO to have 2 different districts and whether for KCP&L should have 2 different utility operating systems underneath the holding company. And I think that's a conversation that we ought to be taking up in whole, and that would be the best way of addressing how we're going to reallocate these costs. I think there are real challenges of reallocating costs, especially in some of the areas that are going to be deeply offended by making such a change, and I just don't think this is the right way of moving forward with it. I'm supportive of staff's position on fuel rebasing. I think putting in the test year amount is appropriate. With regard to the fuel adjustment clause, I have not been a fan of Senate Bill 179 mechanisms in the past. It is the gift that keeps on giving. We had a case that earlier on the agenda that addressed controversies that continue with regard to fuel adjustment clauses. I think at the beginning of Senate Bill 179, the conversation was that a fuel adjustment clause was most appropriate to the utilities that were heavily reliant on gas because of its volatility and fluctuations. Frankly, going back to the days of 05, 06, 07, when Commissioner Davis was chairman, and the real challenges we had in fluctuating gas prices, a fuel adjustment clause really made sense for utilities such as Empire or Aquila, now GMO. I am not a big fan of it, but if we are going to do it, I'm supportive of the proposal of reducing the 95.5 down to the 75.25. I think that gives some incentive for off-system sales, if there are any. I also think it leaves skin in the game for the utility to do its utmost in trying to get the best deal possible for all of its fuel mix. On off-system sales, which is another issue, and I need to look at the memo, I am still struggling with this issue, and because of its size, I'm not prepared to speak on that today. And I suppose there are some sub-issues that if you want to get into those, I'm going to have to talk to Jeff a little bit and go over my thoughts. So that's, on the big issues, that's where I stand.
Okay. You need to get, I mean, we'll decide some stuff, but you need to get those to Judge DePel as quickly as. All right, Commissioner Davis, you have already opined on several issues, so I don't know if you want to.
Yeah, let me just go back here briefly. No to depreciated net book value. I would go along with option 2, the $61.8 million based on the installed cost per kilowatt that Ameren paid for Goose Creek and Raccoon Creek, because I think that price is best representative of what a willing buyer would pay a willing seller in the market. And so I think that is the superior method of determining valuation in this case. That being said, you've got 4 proposed staff reductions. 5. Sorry, I missed one.
That's all right. You're a lawyer.
I'd already flipped to the top of.
They weren't all exactly reductions. I put them. That was the email I sent. The 3 of them were really reasons not to consider Crossroads: deferred income taxes and transmission costs.
Right, and let me think. I'm going to think about deferred income taxes. Let me just go to transmission costs quickly. I would not give them all of their transmission costs. I think they might be entitled to some of those transmission costs, but not the whole enchilada of getting those transmission costs there. I think we already answered the affiliate transaction. The other things, I think we've already answered. Jeffrey, I attend to allocations. Commissioner Clayton, this is from staff's cost of service report.
I think you handed it out.
Okay, all right.
I haven't looked at it.
Okay, and these numbers are highly confidential here, or at least I think the financial numbers are. But in essence, if you look at page 98, staff presented 5 scenarios, which I'm not exactly sure. I mean, I think some of them are just merely for illustrative purposes. The ones that I think are really important. Scenario 2 was staff's position. Scenario 3 was kind of an intermediate position, and Scenario 4 was the company's position. Obviously, Scenario 2 was repugnant, I mean, to the people of, to the city of St. Joe and to everyone. And I would like to advocate to everyone for Scenario 3, which would in essence add 12 megawatts of base load to L&P. It is going to increase their costs modestly. Well, I mean, and modestly may be in the eye of the beholder. I mean, they, you know, they will probably scream about this, but, you know, it's roughly, you know, you can figure from the GMO position to the light, or to the staff position, it's 20%. It's, you know, you're talking about roughly 60 megawatts of difference. So you're talking about a 20% increase of that by 12 megawatts. And, you know, I think Commissioner Clayton's points about consolidating these territories, you know, makes sense, but who knows when and if we're ever going to be able to get that done. And I guess my point is, who knows when and if St. Joe Power and Light will ever be able to procure more baseload generation ever again. And so from that standpoint, you know, I'm going to go back to Ms. Mantle's testimony on the stand where, I mean, you know, I mean, she basically looked at me and I felt like she was pleading with me to do something, get these people a better deal than what they've got. And I agreed with that, or I agree with that. So I would say Scenario 3, you know, assign the 53 megawatts to Light and Power, the 100 megawatts to MPS, which I don't think the company, that's going to cause the company major heartburn. And if you want illustrative numbers with Scenario 3, you can look at page 101 and see what, you know, the difference, you know, Scenario 4 is the GMO proposal, and Scenario 3 would be, this is the staff proposal that I suggest that, you know, we move it to. So, you know, it wouldn't be, you know, staff, or Scenario 2 was actually the staff's proposal that, you know, had people in St. Joe going wild. So this is in essence 20% of that number. And so I would encourage everybody to look at that, and I'll throw myself on your tender mercies and see if you will all go with me on that one. Yeah. Fuel adjustment clauses, you know, I'm absolutely 95.5. I mean, these are prudently incurred costs. Let's see. In terms, yeah, the transmission expenses, that was the one that you know, throws me a little bit, because I don't think we should be picking up the tab for all of the Crossroads transmission expenses over what maybe they would be from, hypothetically speaking, 2 Phantom turbines that were located in Harry's or somewhere else.
South Harper.
South Harper. Going down to the off-system sales margins, I think that the company's 2009 numbers are the most valid and the most reflective, because, you know, after the merger, sale, acquisition of Aquila, you had the movement of Aquila from MISO to SPP. And I think there were very sound reasons for doing that. But obviously, off-system sales are not one of them, in the fact that, you can realize more off-system sales margins in the MISO footprint if you're long on generation than you can in SPP, because there's just a better market for power in MISO than there is in SPP. They're just, everybody's long in SPP, and it's really depressed power prices.
Commissioner Davis, can I just interrupt? We're probably going to go beyond 11 o'clock.
Yeah.
I think we've already lost a
Yeah.
couple hours. Do you have any,
No.
and since we're not voting on anything
Yeah,
today,
I may just
if you
leave.
want to, once you're finished giving your position, we can go, and then you'll have a tally. So, but I want to keep them halfway on schedule, so we'll start up at 11, and then commissioners can feel free to go
And then
down.
just going to the cost of debt issue, I would go with the company and that. So.
Just to follow, I didn't mention the cost of debt issue, but as I understand it, the GMO position is consistent with what's been done in the past, and as long as we're not paying for that higher amount of debt that Aquila incurred during their troubled times, I think that's consistent with GMO's position. I'm on the same page on that.
Okay. And again, Commissioner Jay, you've gone through a lot of these.
Yeah.
Appreciate that.
So I'll be brief. I was with not including it at net book value, and I'm fine with the 61.8 million. I'm no for any of the offsets. Let's see, C's moot, I guess now, right? D, I've already mentioned that. I would say no. I think I've answered everything on the Jeffrey Center rebuild. I would also go with scenario 3 on the IATAN 2 allocation, which I believe is your first bullet point. Isn't it?
Well, scenario 2 is staff's position. I didn't have all of the scenarios.
Oh, okay. Well, I'm for scenario. I'm sorry. Yeah, because it's switched. But I'm good with scenario 3 on that, as Commissioner Davis outlined. The rebasing, I was the soft. No on rebasing. I've changed my position on that. I'm okay with rebasing. 95.5 on the fuel adjustments. On the Crossroad generating station, I am.
That one again.
Yeah, we've already discussed that one. The transmission expenses for the company. I've already said on the off-system sales, the Midas now. And cost of debt, I'm with the company.
Thank you. All right, I had not gone through any of these last week, so I'll take a little longer, but not too much longer. I would not put Crossroads in at the net book value. And, I think the SEC filings, the $51.6 million is probably the most accurate fair market value. And there's some of this is more art than science, and determining fair market value is one of those things that's probably as much art as science. But, the fact that they're included in a regulatory SEC filing is good enough for me. And plus, I think that more accurately reflects the other issues that Commissioner Clayton articulated earlier about the notion of the appropriateness of including this in rate base at all. And the deductions for deferred income taxes and transmission costs, I would be in favor of deducting those. The transmission costs associated with a generation station or generating unit that's 400 miles away from its load center, I'm comfortable discounting those costs. C and D, C is moot. D, I would not be in favor of including the costs of 2 hypothetical turbines. Number 2, the Jeffrey Energy Center, I would be in favor of including it in rate base with no reductions. As an 8% owner, I'm not sure how much say GMO would be able to have had in terms of compelling other behaviors. So B, C, D, and E, I think are just statements of the prudence standard, and so that's fine. Number 3, I'm comfortable with scenario 3 as the allocation between MPS and LNP.
Yes.
Feel the love.
Commissioner Davis makes fine points, and the staff's report in order sets forth those reasons also. So I'm comfortable with that scenario 3. Yes, I would rebase the fuel and purchase power expenses, just because I think that's good policy and it's most in keeping with good regulatory policy to use the actual numbers as opposed to 2007 numbers. I would keep the sharing mechanism at 95.5. I will say, though, that I think it's probably not a bad idea for us to look again at our FAC rules, which I think the statute contemplated was that we would, go through one round of these and then take a look at those rules again, and it may be time to do that sooner rather than later. I would disallow the transmission expenses here as well. Number 6, I am fine with the Midas model, which is consistent with what we attempted to do in the other report and order. And then with respect to the cost of debt, I am with the staff, or not staff's, the company's position using the actual cost of debt as opposed to using Empire as a proxy. I think that's it.
Okay.
You're welcome.
Thank
you.
Yeah, I've done most of this stuff. I would probably also go with the 61.8, just because it's that we have a transaction, but I would also deferred income and transmission costs. I would pull out of there. I mean, the transmission cost is a 400-mile line. This is 400 miles away, and I think I've given you all my stuff on Jeffrey. I'm fine with scenario 3 as well. I've already said I'm for rebasing. I'm fine with 95.5. I think you already had 3 on that as well. I would probably pull out the transmission expenses. Fine with the Midas model, and I am good with the GMO cost of debt. All right, so we have really good direction on this, and I think you can start doing stuff. We're going to have to vote it out on May 4th just to be safe, but we want to. So the judge will work with commissioners and language and making sure we have the final kind of package of everything in order to do that. So
I just want to add, in case people from St. Joe are listening, I just want people to know that I understand that nobody likes a rate increase, but I truly believe that assigning as much of this base load plan to the St. Joe customer base that people can afford is going to be in their long-term best interest over the next 50 years. I mean, I understand that it's going to be a tough pill to swallow for the next, few years, but truly I think over the long term, having that extra 12 megawatts of generation will pay dividends for them in the future, and that's why I'm advocating for this position.
all right, thank you. Thanks everybody for clearing the decks. There are 3 quick things that I want to go through. Next week, the 4th, depending on where we are, and we may move agenda to noon in order to accommodate that. And in the upcoming, we may have to play with the times of agenda a little bit, but again, the 11th will also be determinative of where we are on Ameren. So keep flexible. We'll make sure everybody is up to date on that. And then one other quick budget item. And legislation. Our budget is currently in conference. SB 7. They've got a conference committee. Just a quick update. The House budget implements the governor's recommendation. The Senate budget effectuated a transfer of money from us, but does not contemplate any FTE transfer, and they're going to work that in committee. I would like also, though, to say that if the governor's recommendation, the House budget is ultimately was done, we have enough vacancies in order to transfer. So we've been kind of stockpiling those, so that should be okay. But we'll just see what the outcome is, and we're prepared to fully implement the plan.
Chairman, you go make whatever deals you need to make, and we'll be behind you all the way.
I'm not making any deals. It's up for higher, it's above my pay grade on those. Finally, and I appreciate everybody sticking around. This is the first time in a while we've all kind of been in the same room, and I wanted to wait. But on a personal note, I've been here a short period of time. I have not been able to recognize the previous service of the previous chairman, and I think I want to do that. We have two former chairmen at the table, and I think once you're in this job for a little bit, you begin to appreciate that the tension and the struggles that someone has to go through. So I want to recognize Chairman Clayton's service to the commission as a commissioner, which is continuing, but was previous, but also as chairman. So we have a plaque in the state of Missouri, in case you were wondering what commission you were from. And it just says Robert M. Clayton III, Chairman, 2009 and 2011. An appreciation of your valuable leadership and service, and it's has all the names of the folks.
Very nice.
So
Thank you.
And we look forward and are very pleased to have your continuing contribution.
Very nice. Mr. Chairman, thank you very much. I just want you to understand that I've been able to go off blood pressure medication over the last 30 days, and it's been nice. But I enjoyed my tenure, and I appreciate everyone's work here, and thank you very much, and good luck.
If you have any extra pills, I might.
Exactly.
All right, so we'll go. Well, the hearing's going on, so commissioners feel free. If there's no other business, we will stand adjourned. Thanks, everybody.